Hey, hey, peace and love, peace and love. It's your brother Isaiah again with another one for all the conscious brothers and sisters in the conscious community, keeping the struggle because you know it's through that struggle that we grow. And also, I like to say, it is in fact a slow process that the race is not to the swift, but to those that endure the longest. So make sure you stand for the long. Y'all already know the brother doesn't offer any uh any legal advice to you. Only true and lawful information. Things that I learned, things that I've experienced, things I've actually researched uh, as an educational platform for you to learn. I like to extend all these honors to you because when you honor man and woman, you honor yourself. I like to give adoration to the Most High of all the unique collective awareness of all those who are aware, self-aware, and becoming conscious of self on all levels, knowing myself. Uh, I'd like to say peace to all of you. Me, myself, I'm doing pretty good. I like to also honor all the prophets, all the great men, all the great, beautiful spirits that came before us and blessed us. Uh, I like to acknowledge all of those great bodies of men and women, even those who may not have understood their influence until later when it was too late. Um, uh, I want to get into a topic. I want to talk a little bit about judges today. We're going to read over some things about emotions. We're going to talk a little bit about emotions. Emotions is probably one of one of the ways that the court, pretty much acts upon certain actions based pretty much common through emotions, and it's usually supported by an affidavit. A lot of judges stuff they strike uh, motions. Uh, Also, they deny motions without actually having an actual hearing. So I'm gonna take you to some stuff that you can actually use in understanding what judges are required to do. Uh, I feel that with us, it's just a lack of understanding, meaning we don't know procedures, we don't know rules, we don't know regulations. So it's like going in and you ain't really got nothing to really bounce off of. You going in unaware. He know more about the situation and legally what's going on than you do, and you should have some kind of soundness of the situation at hand. Some kind of knowingness as to what his position is, what he's there for, uh, what's actually taking place, And because we know that a lot of these so-called masters are not judges, right? We always say that they're not judges, they're masquerading, you know, so forth and so on. But we need concrete evidence, you know. I feel like that. Y'all make sure y'all share out the live. Uh, if you come and you go, it ain't for you, you know, because everybody ain't patient. And I want to make sure I ain't casting my pearls to no swine anyway. Swift. You don't need none of these pearls. So be gone. Only those that know, you know. It is what it is. Like a thief in the night. Uh yeah, so these judges, man, they have to follow certain procedures. Certain they're not uh just to the point to where like a lot of people feel like they untouchable or just gotta know, you know, what rules and regulations apply to them. And today I'm gonna read a little something for you to help you get a better understanding of uh let me change this. Give me a second. I'm gonna change that. That ain't what I'm actually going over, but you know, I'm gonna let that ruminate for a second, and then I'm gonna actually find what I'm looking for. Okay. You know, you get all kind of blessings when you stop by. You know, you never know what you might run across. You know, so just just be patient. All right, I got that. Now let me get back to what I was looking. Okay. Yeah, you gotta be delicate with the information too. I treat it like it's something. You know, I I realize I've actually learned some stuff, y'all. Like, man, I can't even tell you what I've learned. Like, I don't even know what I feel. I don't know what to feel. God, it's just unbelievable, man. Some things are just better left unsaid. That's I'm gonna say it like I'm gonna say it like I got to. That's the best way to say it. But you know, seek and thou shalt find. You know, seek and ye shall find. You can find all things that you desire if you truly desire. You know. Uh, but here it is again. As your brother bringing you consciousness and awareness. Okay? Consciousness and awareness has arrived. Okay? Motion. The form. All motions, right? Except those made during pre-hearing conference. So you should make a motion during pre-hearing conference. That's the first, when they first call you in, that the pre-hearing, okay, where they try to determine how you're gonna plead and all of this old stuff that they do, right? All right. That you should have a motion in play prior to that hearing, right? But let's look at what it says a motion is. A request that a judge take a particular action. So now what is a motion? Okay, because I want you to understand. Okay, we gotta stop assuming and guessing, and we got to come to the state of awareness to where you have to become cognizant, responsible, and fully aware of your rights. All right, because ain't nobody gonna give it to you. Okay, you got to go get it if you want it. All right, and if you down with that, then you down with us, because that's what we do here. Okay, all right. All motions must include a statement of the reason supporting them, right? So we know what the motion is. It's a request that the judge take a particular action, right? And all motions must include a statement of the reason supporting them. So you must support that motion, right? Written motions must be filed with the judge or the board. Okay, so the judge or the board. Now let's click on this word judge. All right, because I don't believe in assuming, y'all. Y'all, come on now. You say they doing business, then you say that the courts was a bit, they got an EIN number. Come on, talk to me. Let's talk about it. Judge, any person authorized by what? By who? By what? Hey, that sounds like a damn corporation to me. Hold up. Check it out. Check it out. Any person authorized by what? The board. The who? The board to hold a hearing or to decide a case without a hearing, including the board. Who is this board? Or any member of the board, or an administrative law judge appointed under 5 USC 31050. Well, we're gonna have to go check that out. We're gonna have to go find out what you talking about. Or other employee of the board designated by the board to hear such cases. Oh wow! So y'all, this how y'all get down, huh? Okay, okay. The case shall be heard by the board. You can't say that this is hearsay. You can't say Brother Isaiah making this up or he giving out false information. This is education and informational purposes only. I'm sharing with you what I've learned. And I'm giving it to the collective awareness, to those who are aware. Okay, if you're aware, clap your hands. If you're happy in the work, clap your hands. Come on, man. Y'all remember? So now we understand, like, don't it feel good to have a little bit more understanding of what's going on, okay, of what you're dealing with, so you can understand what's actually happening, because it gotta, a lot of the stuff that they doing, man, it gotta come to a stop. All motions, except those made during the pre-hearing conference and hearings, must be in writing, right? So they gotta be in writing. And all motions must include a statement of the reason supporting them. Written motions must be filed with the judge. So, first of all, if you ain't filing the motion with the judge, because I wouldn't, I was filing it with the clerk. I ain't gonna even stunt. Most of the filings, I never even included the judge. I ain't gonna even lie, I act like he wasn't even in the case. So when you file your motion, you actually supposed to file that motion with the actual judge, right? Or the board, find out who the board is as appropriate. See, because that's the appropriate procedure. And it must be served upon all other parties in accordance with, and then it gives us this section of this part. Now we're gonna tap that. We're gonna go there real quick. All right. Service of pleadings and response. All right. Now, service of pleadings and response. Service by the board. The appropriate office of the board will notify each party to the proceeding that a new appeal has been doctored and will attach to the initial order and proceeding a certificate of service consisted of a list of parties to the proceedings and their designated representatives. Right? And then it says the parties must serve on each other one copy of the pleading as defined and all documents submitted with it, except for the appeal. They may do so by electronic filing in accordance with the postal mail, facsimile, or commercial or personal delivery. Documents and pleadings must be served on each party and each representative, and a certificate of service stating how and when service was made must accompany each pleading. Okay? And the parties and their representative must notify the appropriate board office and one another. And a pleading of any changes to the address telephone number. All right. So a lot of people don't even know who the board office is in in the uh, in the court. But the court has a board. Okay. And just like a board of directors. Now, objections, unless the judge provides otherwise, any objections to any written motion must be filed within 10 days from the date of service of the motion. Judges, in their discretion, may grant or deny motions for extensions of time to filing pleas without providing any opportunity to respond to the motion. Now, you know how a lot of times when we go to court and we be, and it seems like the prosecutor ain't never got to say nothing. And, you know, it's like a one-sided contract, a unilateral contract, right? And most of the time it's because nobody on the other side of a particular or pecuniary interest has made an appearance. So the prosecutor, in his sole discretion, he asks for the board to give him the full rights to act without the other party being present. You see what I'm saying? And treat all parties already named as parties to the agreement. So when he submit that and you don't know how to do what you're supposed to do, you become bound as a party already stated in the and then they come and the court automatically moves against you as if you are already a named party, right? Which you are, but in the capacity other than the capacity of which you should have been in, right? Now, motions is the way you get recognition. All right. Now, the motion is how you can motion to be added into a case too. Okay. So you got to understand the power of a motion and you being able to structure it, make sure that it meets the requirements of what's required for the court, you know, and usually a lot of times their motions to a certain degree, you know, what I do is I usually, if I see a motion of court, I usually mimic that style motion and then make something of a similar style, but make my own, you know, in compliance to the rules and procedures and being able to address the court properly, address the judge or whoever properly so that, you know, everything is efficient because that's where it matters because the judge is the administrator, right? Administering the claims, right? So a motion for an extension of time, it would be granted only a showing of good cause, right? A motion for a protective order, and then you get into the protective order and witnesses and things like that, right? So, you know, this right here is man, like I can't even make it up, like how important it is, but like we're gonna get down to the nitty gritty though, like I said. Give me a second, y'all. I got it. So when you make your motion, make sure you make them to the judge in order to be in compliance with the court rules. A lot of people just file motions into the case. And then you wonder why, when you come into court, the judge say, your motion denied. Because for one, you didn't even file it properly. You see what I'm saying? So that he can address the motion. So you got to actually understand he got to be the holder of the motion in order for him to be able to address it, right? So remember they say the holder of the instrument is entitled to enforce it. So we got to remember what we don't understand commerce in a way that we should. We think we understand it, but if you truly understood it, then you'll know the power of transfer obligations. And that's why a lot of times the prosecutor don't have to say nothing. He's already provided adequate information to the judge concerning the matter at hand and served you. You see what I'm saying? And other parties involved. So he's in compliance. He know of the board. You see, you don't know nothing about the board. So if you don't know nothing about it, you don't know nothing about sending nothing to no board, other court, and being in compliance with any kind of court rules or regulations. If you've never been taught or this has never been exposed to you to the point to where you understand those things, you know what I'm saying? So it is what it is. Now, we ain't gonna do no faking now. Well, that's one thing. We're gonna do no faking now. We're gonna get straight to it. Oh look, let me pull this up. We're gonna get straight to it. See, over here we get knowledge. And when I come, I only come when I got something to give. Okay? That's how I go. Something to give. Blessings. And if you want a consultation, you want to learn more about what it is that we do, you gotta, you know, watch will be opening up. All right, so now we talk about the hearing and appeal procedure. All right, so this part sets the procedures governing the conduct of hearings and the insurance of initial and final administrative decisions of NOAA involving alleged violations of law cited in 904, subsection 904.1c, and any other law or authority administered by the NOAA and regulations implementing these laws, including civil penalties, assessments, and permit sanctions, and denials by separate regulations. These rules may be applied to other proceedings. Now let's go right here to this 904C. The following statutes authorize NOA to assess civil penalties imposed, permit sanctions issued, written warrants, and seize and forfeiture property response to violation of those statutes. And then they got all these different, you know, right? course, I'm not going to read through all of it, but it's all these different things that are applicable. All right, hearing request and case docket. If the respondent wishes a hearing, now, oh, I don't too, too. Hold up, y'all. Let me pull up something. All right. Okay. Now let me share this again. Okay. So we got the filing of documents, right? And the pleadings and the papers. When you're dealing with documents and proceedings, they must be filed directly with the office of the administrative law judge and be served on all parties and conform with applicable requirements, right? So, like, all this is all the procedures, like a lot of the procedures that they use on hearings, right? And then the judge has all power and responsibility, right? Once the documents are served properly, things are done right in accordance to. That's why they be telling you, we advise you to get an attorney or something like that, so that you can follow proper procedures and to preside. See, so the judge has the power and the responsibility necessary to preside over the parties and the hearing, to hold pre-hearing conferences, to conduct the hearing, and to render decisions in accordance with these regulations, right? And then they give you like different parts where you can go and you can read it, right? That's why I say like a lot of these documents, they take you like to other places within the same, like me, and I'm a researcher, so I like to really read and research. So this says the government organization and employees, right? So this has something to do with government employees, right? So when I go in here and I start looking around, okay, we got adjudication. This section applies according to the provisions thereof in every case of adjudication, right? Required by statute to be determined on the record after opportunity for an agency hearing, right? Except to be to the extent that there is involved a matter subject to the subsequent trial of the law and the facts de novo in a court. And then it get to going into, so it's saying a person entitled to notice of agency hearing shall be timely informed of. All right, so maybe when you go into court, it's an agency hearing, and you don't know. Maybe you're not, you see, because it's talking about an opportunity for an agency hearing, right? So if I was to actually look up an agency hearing, right, well, I wonder what will actually pop up, but before I go there, I'm gonna keep reading real quick, right? So this how, when I read, certain things pop out, they stand out, like an agency hearing, and it's talking about a person entitled to notice of so entitled to notice or service of process, right? Or when they say that they have to give notice, they have to serve you, okay? Uh, so when you start putting the pieces together, it'll start making a lot more sense to you. The time, place, and the nature of the hearing, right? The legal authority and jurisdiction under which the hearing is to be held, and the matter of fact and the law asserted, right? When a private person, when private persons are the moving parties, other parties to the proceedings shall give prompt notice of issues controverted in fact or law, and in other instances, agencies may by rule require responsive pleadings and fixing the time and the place for a hearing. Due regard shall be had for the convenience and necessities of the parties or their representatives. Right? The agency shall give all interested parties an opportunity for the submission and the consideration of facts, arguments, offers of settlement, or proposals of adjustments when time and the nature of the proceeding and the public interest permit, and to the extent that the parties are unable so to determine the controversy by consent, hearing, and decision on notice, and in accordance with section 556 and 557 of the title, the employee who presides at the reception of evidence pursuant to section 556 of this title shall make a recommendation, decision, or initial decision required by section 557 of this title unless it becomes unavailable to the agency, right? So now it's talking about, like, when they talk about fairness, right? Uh, all the things that the judge and things is, now I'm gonna show you something else so that you can understand that they do have certain things they have to follow. Okay. Now, this right here is called, it's called rules of conduct, okay, for judiciary, okay? So you gotta, like I said, nobody's going to teach you this. Nobody's going to, you gotta learn for yourself. And I mean, that's part that comes with the territory. Can't get around that. So in order for you to become better, you got to know more to do better, right? Now, when we read the application section, establish when various rules apply to judges or judicial candidates, right? Applicability of this code, all provisions of this code apply to all full-time judges, commissioners, and masters. Part 1, Part 2, and 3 of this section identifies the specific provisions of this code that apply to senior judges and other part-time judges, respectively. Canon 4 applies to judicial candidates, right? It says, a judge within the meaning of this code is anyone who is authorized to perform judicial functions within the judicial branch. Now, we go to the comments, because Brother Isaiah, I'm real big on the comments, and I can't stress it that you need to start reading comments because it helps you better understand what it's talking about. Now, the rules in this code have been formulated to address the ethical obligations of any person who serves as a judicial function and are premised upon the submission or what is it? Substation that the uniform system of ethical principles should apply to all those authorized to perform judicial functions. In recent years, many jurisdictions have created what are often called problem-solving courts, in which judges are authorized by court rule to act in non-traditional ways. For example, judges presiding in drug court and monitoring the progress of participants in those court programs may be authorized and even encouraged to communicate directly with social workers, probation officers, and others outside the context of their usual judicial role as independent decision makers on issues of facts and law. So you see how it breaks it down, right? It breaks it all the way down. Then it talks about time municipal judges, senior judges, serve part-time basis. It start breaking down all these different things in the comments. So I like to actually read the comments. I think you should also do that. That's real good for, learning purposes, right? Now we go into the preamble. An independent, fair, and impartial judiciary is indispensable to our system of justice. The United States legal system is based upon the principles that an independent, impartial, and competent judiciary composed of men and women of integrity will interpret and apply the law that governs our society. Thus, the judiciary plays a central role in preserving the principles of justice and the rules of law inherited in all rules contained in this code are the precepts that judges individually and collectively must respect and honor the judiciary office as a public trust. So he's sitting there to see the trust. So you're actually, when you go to court, they're actually in trust. And this is not what I'm making up. We ain't got to guess it. We're reading it from the judiciary code. It's telling you that it's a seat of trust. And strive to maintain and enforce confidence in the legal system. So he's sitting in an office of trust. Judges should maintain the dignity of the judicial office and avoid both impropriety and the appearance of impropriety. They should aspire to conduct that ensures the greatest possible public confidence in the independence, impartiality, integrity, and competence. So it's saying that if you're going there and the judge arguing with you and talking to you crazy, there's no impartiality, there's no fairness here. You're already calling me out my name, you telling me you're gonna lock me up. You telling me that this is a one side, ain't no way. You ain't talking to the prosecutor that way. So that in a sense shows you that that person is outside of his judiciary conduct. He's not acting within the ramifications of what he's responsible to do, right? Now check this out. The judiciary of judicial conduct established standards for ethical conduct of judges and judicial candidates. It is not intended as an exhaustive guide for the conduct of judges and judicial candidates who are governed in their judiciary and personal conduct by general ethical standards as well as by the code. The code is intended, however, to provide guidance and assistance and assist judges in maintaining the highest standard of judicial and personal conduct, and to provide the basis for regulating their conduct through disciplinary agencies, right? Now, we're going to get into this. Yeah, we got, this is, like I said, that's the preamble. Now we're going to go into the scope. And what's the scope of this, right? Go into the scope. The code of judicial conduct consists of 4 canons. Number 1, under each canon and comment that generally follows and explains each rule. Scope and terminology section provided additional guidance in interpreting and in applying the code, right? An application section established when the various rules apply to judges and judicial candidates, right? Now, the canon states the overarching principle of judicial ethics and all judges must observe. Although a judge may be disciplined only for violating a rule, the canon provides important guidance in interpreting the rule. When a rule constraint contains a permissive term, such as may or should, the conduct being addressed is committed to the personal and professional discretion of the judge and candidate in question, and no disciplinary action should be taken for action or inaction within the bounds of such discretion, right? The commitment that accompanies the rule serves 2 functions. First, they provide the guidance regarding the purpose of the meaning and the proper application of the rule. They contain explanatory material and in some instances provide examples of permitted and forbidden conduct. Comments neither add to nor subtract from the binding obligations set forth in the rule. Therefore, when a comment contains the term must, it does not mean that the comment itself is binding or enforceable. It signifies that the rule in question, properly understood, is obligatory as to conduct at issue, right? So it's saying that it's not saying that it's a must that they do it, because evidently as we can see, they don't have to do nothing. But it's basically saying that if at the time he's administering his office, if his conduct doesn't meet the requirements required for the conduct at that time of administration, then he violated the rule. So he can be held accountable for that, right? Second, the comment identifies aspirational goals for judges to implement fully the principles of the code as articulated in canon. Judges should strive to exceed the standards of conduct established by the rule, holding themselves to the highest ethical standards and seeking to achieve those aspirational goals, thereby enhancing the dignity of the judicial office, right? And the rules of code of judicial conduct are rules of reason that should be applied consistent with constitutional requirements, statutes, other court rules, and decisional law, and with due regard for all relevant circumstances. That rules should not be interpreted to impinge upon the essential independence of judges in making judicial decisions. So, like, these rules, man, I can't make it up. Like when I say you gotta get into like knowing things that like this, because this is what will actually expand your level of understanding, your ability to move with more confidence, right? Now look, check this out. Appropriate disciplinary authority, right? Means authority having responsibility for initiation of disciplinary process in connection with violations to be reported. All right, so whenever they violate, they got a disciplinary board, right, that they deal with. Contributions means both financial and in-kind contributions, such as goods, professional, or volunteer services, advertising, and other types of assistance that is obtained through the recipient otherwise would require a financial expenditure. The minimus in the context of interest pertaining to recusal of a judge means an insufficient interest that could not raise a reasonable question regarding the judge impartiality. Right? And then it goes into all these different things, right? So then it talks about a fiduciary. So they recognize, see, all these different institutions recognize fiduciaries, including relationships such as personal representatives, right? Executors, administrators, trustees, attorney in fact, under power of attorney, right? Conservators or guardians, right? So, like, when you understand, like, the means, like, you got to know what the court, so it says attorney in fact. It didn't say attorney at law, right? It says attorney in fact, right? Now, why is this important? Because I'm going to go out of this, right? As important as this information is that I'm showing you, I hope that you like, you share out the live. You got to catch Brother Isaiah when I'm in the means of in between time. In the meantime, you got to catch me, because You never know what you might run across when I'm on here and what I might drop, because I have a lot. This is scope terminology. Now, all these different things, like when we go to Canon 1, all right, when you go to Canon 1, this is how it is, all right? So this is 1, compliance with the law. A judge shall comply with the law, including the code of judicial conduct. So now you know why you need to know the code of judicial conduct, because when his conduct does not meet judiciary standards, then you got to know the judicial codes in which he's violating, and then you got to put that into his presence, give him judicial notice of his judicial conduct, which is not in compliance to the code, and then you demand for compliance, right, of his judicial conduct. Right now, understanding that you have power, don't let them think you don't. A judge shall act at all times in a manner that promotes public confidence and independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety. Okay, so what is impropriety? Because a lot of y'all might not even know what that is, right? So we're gonna say public confidence. This is when I say the comments. Public confidence in the judiciary is eroded in improper conduct by judges. A judge must avoid all impropriety and the appearance of impropriety. Right? Now look at this. It says a judge should expect to be subject of public scrutiny. Huh? That means that instead of you worried about the judge, he should be worried about how you view his responsibility and his action, because you're supposed to be of the highest public office. And since you are the public judiciary, all right, we need to figure out, like, look, check this out. A judge should expect to be the subject of public scrutiny that might be viewed as burdensome if applied to other citizens. Meaning he can't do nothing wrong. He got to walk around like he an angel, right? And must accept restrictions imposed by the code, right? Conduct that comprises or appears to comprise the independence, integrity, impartiality of a judge undermines public confidence in the judiciary, because it is not practical to list all such conduct that rules is necessarily cast in the general term. It says a judge shall not participate in activities that promote ethical conduct among judges and lawyers, support professionalism within the judiciary and the legal profession, and to promote access to justice for all. Actual improprieties under this standard includes violations of law, court rules, or provisions of the code. The test for appearance or impropriety is whether the conduct would create a reasonable mind and perception that the judge's ability to carry out judicial responsibilities with integrity, impartiality, and appropriate temper is impaired. Now look at that. Now how many of y'all have been to court and seen the judge get outside of his character, yelling, telling you, you got one more time, sir, one more time in my courtroom? How many times y'all have seen them do that? Huh? That's a violation of judicial conduct. Dude, you acting more like a one of the people who wild than we are. How you sitting in that seat and you acting like my auntie at the house, or one of my little cousins who, when she get mad because she don't like what I say. You know what I'm saying? You up here yelling and screaming at me, you know? So when you realize that his conduct is out of whack, something is impaired in the way he thinks, because he don't know how to be impartial, right? It says a judge should initiate and participate in community outreach activities for the purposes of promoting public understanding of confidence in the administration of justice and conducting such activities, and a judge must act in a manner consistent with these codes, right? Now let's go back. Okay? We ain't done. It says a judge shall not abuse the prestige of judicial office to advance the personal economic interests of the judge or others, or allow others to do so. So he ain't supposed to be working to help nobody make no profit. It said it is improper for a judge to use or attempt to use his or her position to gain personal advantage or differential treatment of a kind. For example, it would be improper for a judge to allude to his or her judicial status to gain favor treatment in encounters with traffic officials. Similarly, a judge must not use judicial letterheads to gain an advantage in conduct of his or her personal business. In addition, the need for every recommendation of official stationery to recite that it is the personal act of the judge's question. Recommendation letters of the type authorized by judicial codes are reviewed by sophisticated individuals with sufficient knowledge that reference are private, not official acts reference sent to educational institutions, governmental agencies, scholarship committees, and businesses are not likely to be misrepresented as court acts, right? So when they don't, when a judge doesn't do things in accordance to the judicial code, okay, let me go back. So when you go to the canons, you got citations of Supreme Court rule, right? So these are, all these rules that we read, these are the Supreme Court rules, right? I don't know how I got back to that. Let me see, you got Rule 2 is Code of Judicial Conduct. That's Rule 2. Rule 3 is Reserve. Rule 4 is Rules of Professional Conduct, right? So when we go to Rules of Professional Conduct, right, you got the preamble. Now, I want to show you this because I feel like we been taken advantage of because we don't know stuff. You know what I'm saying? And the worst thing to do is to not have knowledge or to not know the things that you need to know so that you can protect you and your family from these corrupt people, right? It says a lawyer, as a member of a legal professional, is is a representative of clients, an officer of a legal system, and a public citizen having special responsibilities for the quality of justice. As a representative of clients, a lawyer performs various functions. An advisor, a lawyer provides a client with an informed understanding of the client's legal rights and obligations and explain their practical implications. As advocates, lawyers ceaselessly asserts that the client's position under the rules of an adversary system, a negotiator. A lawyer seeks as a result advantages to the client, but consistent with the requirements of honest dealings with others. As an elevator, a lawyer acts as an examining client legal affairs and reporting about them to the client or to others, right? So it goes into like what they are, what their rules are. I'm not gonna read it all, right? And then it got, so when you go into number, all right, so this is number 4, that's the preamble. Then when you go to 4.1, it takes you to client lawyer relationship. All right. And when you go here, it's to kind of show you what it's about. Now it says belief denotes the person involved actually suppose the facts in question to be true. A person's belief may be inferred from circumstances. All right, so first of all, do you believe that you're actually responsible for the charge? And usually that's what most lawyers ask you when they first talk to you. I know because I've been incarcerated, right? Confirming in writing. When used in a reference to informed consent of a person. So like when the judge said you pleaded guilty or anything like that, it's saying, this is what it's talking about. It said confirmed in writing when used in reference to informed consent. So when you say, when they say it's a trial and you say, I never gave informed consent to a plea of guilty, can you show me my informed consent? You see, they have to show proof. And they usually don't have it because there ain't no fool gonna, certify something against itself, which would be foolish, right? All right. Denotes informed consent that is given in writing by a person or a written that a lawyer promptly transmits to the person confirming an oral informed consent. For the definition of informed consent, if it is not feasible to obtain or transmit the writing at the time the person gave informed consent. So like say for instance, like if a lawyer put in a plea for you and you didn't put the plea in, but the lawyer put it in on your behalf, or a lawyer issued some kind of motion or something against something that should have benefited you, or you say you put a document in and then the lawyer did another document after he found out you did a document and offset your document, stuff like that, and you didn't give him informed consent to do that, right? Then he can't do it. Like anything that they do, they can't make a ruling or do anything without your informed consent. So what they do is they get what they call tacit or implicit, right? By moving forward without no objection, without nobody making any informed disputes against any conduct by the judge that may be improper. That's why I'm showing you, like I didn't go all the way into everything about the judge's conducts and everything because I want to leave some room for y'all to go and do this study in your own state for yourself, for your own benefit. I just kind of want to show you some things for your own, but so that you can have some things to, other things to look at, to study outside of just, commerce. Because a lot of people just study negotiable instruments, you got to know more than that. That's the surface, right? All right. Now it says firm or law firm, and then it talks about the law firm, then it talks about fraud, right? It says denotes conduct that is fraudulent under the substantive or procedural law of applicable jurisdiction and has purpose to deceive, right? Informed consent denote the agreement by a person to a proposed course of conduct after the lawyer has communicated adequate information and explanation about the material risk of any reasonable available alternative to the proposed course of conduct. Then it says knowingly knows denotes actual knowledge of a fact in question. A personal knowledge may be inferred from circumstances. So like when they call you in the court and they get to talking about the matter at hand and you get the acknowledging it, saying you were driving on such and such, objection, I don't consent. I don't consent to any part of these. See, if you start talking about, well, I wasn't driving, I was they got you because that shows personal, knowledge of the events. So when you understand how, like a lot of times you hear people challenge jurisdiction, and then you hear the judge continue to say, or he'll talk to the prosecutor and say, well, what is the state recommending? And then the state will start talking about its recommendations. And then the judge will start talking again like they moving forward. And then they'll get you to say, well, what are you going to do? Or do you want your motion or something? Then you get talking and stuff and participating. Now they got you back involved again because you was just challenging jurisdiction. And now you're talking about a motion. So now it's like, when you understand the trickery, the different things that they use to pull you in, right? To use. All right, so then you got reasonable. My bad. Partner denotes a member of a partnership, shareholder of a law firm, organization, organized as a professional corporation, or a member of an association authorized to practice law. Reasonable when in relation to conduct by a lawyer denotes the conduct of reasonable, pertinent, and competent lawyer. Reasonable belief when used in reference to a lawyer denotes that the lawyer believes that the matter in question and that the circumstances are such that the belief is reasonable, right? So it's almost like playing a game to me, if you ask me. So the lawyer is using a reasonable belief that the circumstances in question are reasonable, right? Reasonable should know when used in reference to a lawyer denotes that the lawyer of reasonable pertinence and competence would ascertain the matter in question, right? So all these different things, and then when you go into like to all of this right here, it explains to you what all of it is pretty much pertaining to. So let me go back up. But these are the things you want to go and read to get a better understanding, like, and then it talks about like competence, right, of an attorney. So he's supposed to have knowledge, all these different things that's required, right? And then we got the scope of representation, like I said. Now listen to this is one of the most important aspects that you need to know, right? Because when you, especially if you already have a lawyer that's already representing you, right? Or representing your person in the court proceeding, because they can't represent the spirit, They can only represent flesh in which you travel within. They can't represent you. They can only represent your body because you don't want to represent, or you don't want to lord over it, or whatever you want to call it, right? A lawyer shall abide by the client's decision concerning objectives of representation, right? And shall conduct with the client as to the means by which they are to be pursued. A lawyer shall abide by the client's decision whether to accept an offer of a settlement of a matter. In criminal cases, a lawyer shall abide by the client's decision after consulting with the lawyer as to a plea to be entered, whether a waived jury trial, and whether the client will testify. A lawyer representation of a client includes representation by appointment, does not constitute an endorsement of the client's political, economical, social, or moral views or activities. So actually, when you have a lawyer that's assigned to you by the court, then that's coming from a higher authority or a state where the court is acting as a lord and treating you as if you're a ward, where they have to provide certain protections and certain representations on your behalf for your benefit, even if you don't know how to use it, right? So most of us will say a lawyer is a bad thing, but it's really not if you really understand how to use the lawyer to your advantage. You know what I'm saying? He can speak and do things that you probably can't do because he knows certain procedures better than you. Okay, when it comes to that specific procedural platform, okay, I understand that aspect of it. And the lawyer may limit the scope of representation if the client gives informal consent in writing signed by the client to the essential terms of representation, any and the lawyer's limited role. See? So all you got to do is give what? Informed consent in writing. All you got to do is be signed by you. Who? The client, right? Who you work for. To the essential terms of representation. See? So, like, if you got a lawyer right now and you like, this lawyer, he just doing, and my son, and see, my son, he been dealing with this case, and this man just did, I don't know, we've been paying this man, and this man just do, you ever heard somebody talk like that? That just shows somebody that don't know how to delegate their affairs. Because if you did, then you would understand that he works for you. All right? You just ain't giving him no agreements to perform under. You're not putting him under authority, right? So you can give him a limited representative role. Even in when you have car accidents and you have an attorney, you're supposed to provide him with a limited power of attorney. And in that power of attorney, you must specify like what you want that attorney to do. You see what I'm saying? What authority he has and what authority he don't have. And what he must do before he do anything on your behalf. You can instruct them to the interest, proceeds, or anything, because that's what you have the legal authority to do, right? Right? Use of a written notice and consent form, substantially similar to that contained in the comment of Rule 1.4 creates the presumption that the representation is limited to the lawyer and the service described in the form, and the lawyer does not represent the client generally or in any matter other than those identified in the form. The requirements of the writing signed by the client does not apply to an initial consulting with any lawyer or pro bono services provided through a nonprofit organization or court annex program or bar association or accredited law school. services provided by a nonprofit organization funded in whole or in part by a legal service corporation. So now you know what they be giving you when you come in there. Okay? This is the public, well, we call it the public pretenders program. No, but then again, you got some legal professionals that's running to be legally professional in their own law firm. So you run across a good one, I done ran across a couple of good ones that were some real good guys, man. Everybody ain't bad, John. Can't just look at the whole system. Say, oh, all of them with the system. No, some of them they got to go through the system to get to where they're trying to get to. So in the process of doing that, you might run across a couple of good characters in your transitions, such as I have, right? So, but it's good to know, it's good to know things like this. Very important that you know that, right? And otherwise, unrepresented parties to whom limited representation is being provided or has been provided is considered to be unrepresentative for the purposes of communication, right? It says, except to the extent that the lawyer acting within the scope of limited representation provides other counsel with written notice of the time period which other counsel shall communicate only. So it's good that you know these things, right? So all these different things, the diligence, the communication, the fees, all right. Now I just want to get to all right, so we got the confidential of information. I got to jump around a little bit for time's sake. So a lawyer shall not reveal information related to the representation of the client unless the client gives informed consent. The disclosure, now you know what it means, like on your credit report when it says that when you challenge a debt and you ask them to show informed consent, that they have informed consent from you as the owner of the debt to collect the debt. That's what it's talking about. It's not talking about the fact that they have a signed instrument in their possession that was transferred to them. It's asking, do they have informed consent to collect? Okay, so I just want you to see, as I see certain stuff that I feel that's applicable in other areas in which we study to deal with the same things that we're dealing with, I have to show you how this is applicable to that. This is what informed consent is, okay? So understanding that anybody billing you, collecting, they have to have informed consent to do that from the actual owner or authorized user of that estate, right? The disclosures is implied, authorized in order to carry out the representation, or disclosures is permitted by Rule 401. A lawyer may reveal information relating to representation of a client to the extent the lawyer reasonably believes necessary to prevent the death, substantial bodily harm that is reasonably certain to occur, right? To secure legal advice about the lawyer's compliance with these rules, to establish claims and defenses on behalf of the lawyer in controversy between lawyers and clients, to establish a defense to criminal charges and civil claims against the lawyer based upon conduct in which the client was involved or responds to allegations in proceedings concerning to the lawyer's representation of the client, to comply with other laws or a court order, or to detect and resolve conflicts of interest arising from the lawyer's change of employment or from changes in the composition or ownership of a firm. But only, right? So it basically breaks it down. Then when you go into comments, this kind of like really helps you understand like what it's all talking about above. So if you didn't understand this aspect, maybe when you go down here in comments and read it, it'll make way more sense to you. And then that'll help you. That's why I'm showing it to you, because I want you to know that they do have it set up for you to learn. And if you want to learn, it does require for you to study. And that's all part of it. But like Like even what I'm doing right here with you now, this is something you have to learn how to do on your own. Okay. Now, conflict of interest, current clients, except as provided in Rule 41.7b. A lawyer shall not represent a client if the representation involves a concurrent conflict of interest. A concurrent conflict of interest exists if the representation of the client will be directly adverse to another client, or there is a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibility to another client, a formal client or a third person, or by personal interest of the lawyer. Notwithstanding the existence of a concurrent conflict of interest, a lawyer may not represent a client if the lawyer reasonably believes that the lawyer will be able to provide competent and diligent representation to each affected client, and the representation is not forbidden by law. So it goes into it goes into it goes into conflict of interest, like a lawyer cannot enter into a business transaction with a client or knowingly acquire ownership, right, or security interest adverse to the client unless the transactions and the terms of the lawyer acquired interest are fair, reasonable to the client, and are fully disclosed and transmitted in writing in a manner that can reasonably be understood by the client. The client is advised in writing of the desirability of seeking and giving a reasonable opportunity to seek the advice of independent legal counsel on the transaction. All of that. So it deals with all of that. It even deals with it even talks about like trust accounts and everything, right? Let me show you. Look at this. It says a lawyer shall hold property of a client or a third person that is in the lawyer's possession in connection with the representation separate from the lawyer's own property. A client or a third party's funds shall be kept in a separate account designated as a client's trust account, or words of similar import maintained in the state where the lawyer's office is situated, or else if the client or the third person consents. Every client trust account shall be either an IOLTA account or a non-IOLTA trust account or exempt trust account. No earnings from. Now look, man, did you know that? How many people you think knew that they was creating trust accounts? Because I sure didn't know nothing about it. You know what I'm saying? I got to reading this. I was like, whoa, so you mean to tell me? So a client, they have what's a client trust account, right? Or exempt must be approved institution. Every lawyer practicing or admitting to practice in this jurisdiction as condition thereof shall be collectively deemed to have consented to the overdraft reporting and production requirements mandated by the regulations adopted by the advocacy committee, advisory committee, right? See this right here, man? So you can tell me I can tell my lawyer to transfer the obligations from my trust account. You gotta be playing with me, man. Come on, man. You can't be serious, man. Y'all see this stuff? Look, look at this, man. I can't make it up. Look at this, so much information. Look. Oh man, I ain't gonna even. I just wanted to show it to you because a lot of people, a lot of y'all don't believe. But hey, listen, man, I can't make this up, man. Even if I wanted to, I couldn't make it up. And they break down what the accounts is, so you'll know what they are. Uh, so let me look at this. You see all these different things, but like I'm gonna get up out of that. I'm going back. Okay. So, but like I was saying, all this stuff right here you can find in your judicial codes. It's a whole lot of information in here, man. Like I said, they got civil forms, they got criminal forms, expungement forms, municipal form, name change form, probate forms. Everything you can think of is, you know, a filing information sheet, right? So, like, say for instance, if I wanted to, like this information sheet, is for domestic relation cases, probate, non-domestic cases, criminal. This for criminal and this confidential redacted informational filing sheet. And what these are is these filing sheets are like what they use for court, confidential case filing information of criminal, right? State versus, and then you got the defendant, all the information, right? Race, ethnicity, all of that, right? All this information, it's so much information that a lot of people ain't never even had a chance to even, because they don't even know nothing about it. They never even heard of a lot of stuff. And I'm gonna show you something that's gonna blow your mind. You know how we say, well, I'm gonna show you two things before I get ready to get up off here, right? For your benefit. All right. So a lot of times when you go into court, all right, especially if you're going to represent the estate, if you're going to represent uh, the individual uh, principal, right? If you're going to say that the principal is the all capital name principal, and you're the man or the woman acting as the agent under that principle, right? Then you got to also know how to put certain documents on file with not just with the court, but with the judge. Because now you know the judge is the one who needs to receive these documents, right? So let's pull this up real quick. All right, so I'm gonna pull this up for because every state has a power of attorney act. Okay, I'm gonna pull it up. I'm pulling it up for Missouri. Oh, sit on, man. I'll pull it up for Michigan. I just want to show you uh, that they all have these acts, right? And it ain't that it's the individual. The people are incompetent. Okay, so when you're incompetent, then you don't know the acts, you don't know the things that you should know, which could give you standing, right? This is a Uniform Power of Attorney Act. This is for, I think, Minnesota, right? But it talks about actual knowledge, means knowledge and fact. Agent means the person granted authority to act for a principal under a power of attorney, whether denominated an agent, attorney in fact, or otherwise. Agent includes an original agent or a co-agent or a successor agent, right? And a person to whom an agent authority is delegated, right? And then it talks about court, the states, durable, all of these different things, right? So you go into it. Then right here says an individual has impairment in the ability to receive and evaluate information. Now, why would it say that? Because when you receiving information, you're receiving legal information. And you're not able to evaluate that it's not pertaining to you personally. This all is pertaining to you in some sort of legal capacity. So when you receive legal documents in your legal name and you personally think it's talking about you personally, that shows that you have an inability to receive and evaluate information or to make or communicate decisions, right? Even with the use of technological, excuse me, y'all. I can't even pronounce, get the word off the tongue, technological assistance. And then it says the individual is any of the following: missing, detained, including incarcerated and penal system outside the United States, is unable to return. A person is an individual or a corporation, including a fiduciary of an estate or a trust, right? A business partnership, limited liability company, association, joint venture, public corporation, government or governmental subdivision, agency or instrumentality, or any other legal or commercial entity. So it's telling you that now this word person, this word individual or corporation. Now, why would it say individual or corporation? Because an individual can be an established corporation if you establish it as a corporation, right? But the key thing is that it's a commercial entity. This is the most important aspect, is that an individual falls in a lineup of a commercial entity, and we all operate as individuals, which are commercial entities. Okay? Now, when you say unless content otherwise, a power of attorney. A power of attorney means a written record. All right, it's a written record that grants the authority to an agent to act in one or more matters on behalf of the principal, whether or not the term power of attorney is used. See? So, like when you're reading this stuff right here, it'll help you understand. So now you got a person other than the principal, an agent under a power of attorney in question, acts by the principal or the agent under the power of attorney to take a specific action or action in reliance of the power, right? And the power of attorney itself or a copy of it has been presented to and received by the person that is asked to take action in reliance on the power and described in subparagraph, right? I, presently exercisable with respects to a power of appointment, means that the power of appointment is exercisable by the appointee, right? At the relevant time. A power of appointment that is not exercisable until the occurrence of a specific event. The satisfaction of an ascertainable standard or a passage of a specified period is presently exercisable only after the occurrence of a specified event, right? The satisfaction of an ascertainable standard or a passage of a specified period, a power that is exercised only by the will is not presently exercisable. All right, and then the principle, right, is the individual, right? The individual, which is the entity. Remember, I showed you above that an individual is an entity. So the individual entity who grants authority to an agent and a power of attorney. So the principal has to grant the agent, the man who uses the principal record. The principal is the record that is used in all of the contracts. When you act in an agreement, even with the courts, the principal would always be the record, the named person in everything, okay? Known as principal, the principal character, the principal person involved, okay? Which is the legal status and standing and characteristic of a man or a woman. It's very important that you understand that, not identifying the man directly, because man is not the object or the concept itself. Man is the actual divine essence and intellectual livelihood of that person. And most people never become self-aware, so they never learn these type of truths. So it's a sound form, but the principle would always be the named person, okay? And the individual, right? The entity, right? Whether you look at it as flesh or not, it's still an entity who grants authority, right, to an agent in a power of attorney, right? So the entity is granting the agent the power to attorney, right? And property is anything subject to ownership, meaning that anything that the principal owns and that the agent touches is subject to any claims and defenses that the principal has in such property through such agent's claim, right? And a record means information inscribed on a tangible medium that is stored in an electronic and medium and is retrievable in perceivable form. So when you got a record of authority, it's recorded. You can go pull your authority from the record and show you have legal authority to act. Okay, so in order to have principal authority to manage something, right, then you have the right to do it. If God gave you the body as a gift, and this gift is your blessing, and you are the authority over the flesh, and the flesh has been recorded as a person, then you should own that person directly. You should be conscious enough to claim your property. You know what I'm saying? To understand your awareness, your rights to be alive and to have and own and control property, not be subject as a person, right? Signing means to do either of the following: intent to authenticate or adopt the record. So when you sign, right, either you're authenticating it, saying that it's legit, or you're adopting it. Right? To execute or adopt a tangible sin, to attach or logically associate with the record, an electronic sound, symbol, or process. So what is an electronic sound, symbol, or process? An EFT. That's what an electronic sound, symbol, or process is. An EFT, an order to pay, right? A state means a state of the United States. So we know that the state is what? The District of Columbia. Like I said, federal. If the state is the District of Columbia, and then when, like, if I look this up, the state of Missouri, it's gonna have the same state, right? If I look up the state of Texas, it's gonna have the same state. State of Florida, it's gonna have the same state. So when it says state, and you see state on the top of your state like this, it's talking about the district states. The district has a union states, just like the United States of America Republic has union states. Okay? A collective union, right? Stocks and bonds, right? And then it says, notice or knowledge of a fact involving the power of attorney. Now, this is where it's important. Except as otherwise provided in this section, a person has knowledge of the fact involving the power of attorney if one or more of the following are true. The person has actual knowledge of the fact. The person has received notification of the fact from all of the facts and circumstances known to the person at the time in question. The person has reason to know of the facts. The entity that conducts activities through one or more of the employees has notice or knowledge of the fact involving the power of attorney, a principal or an agent only from the time the information is received by the employee conducting the transaction, or from the time the information would have been brought to the employee's attention if the entity had exercised reasonable diligence, right? The entity that conducts, why is it saying an entity? So, because it's an entity that conducts the activities. You're just dealing with one of his agents. But you gotta realize when you're dealing with these companies, you're dealing with an entity. When you go to the shoe store, you're dealing with an entity. When you go to McDonald's, you're dealing with an entity. Understand that. And its employees. Know what's going on. Wake up. Why y'all still sleep? You can create your own entity. As using this section, reasonable diligence means maintenance and reasonable compliance with reasonable routine for communicating significant information to employees conducting transactions. So, hold up. So we read the Power of Attorney Act, and it's telling us that reasonable diligence means the maintenance and reasonable compliance with reasonable routines for communicating significant information. I wonder what could be significant information to whoever, whatever employee of whatever company. I'm just here to make you think. Conducting the transaction. A reasonable diligence does not require an employee of the entity to communicate information unless the communication is a part of the individual's regular duty or individual knows a matter concerning the transaction will be materially affected by the information. So that's why you got to make sure you get it to the right person. Transaction means transaction that is conducted for the entity that involves the power of attorney. Huh? Now, can I? Now do I have to explain this? Like, like if you've been doubting, if you think that we just make this, we don't make this up. Some of us just a little bit better at others at exposing and showing you the truth. Okay? Where it's hidden, if you know how they say the truth is hidden in plain sight, is right there in your face and you can't even see it. So you know how you go to court and they be like, oh, you can't act as attorney. You got to, do you work for the bar? You don't need to work for the bar. We got a power of attorney act. Do you work for the bar? You don't need to work for no bar. You don't need a barcode. Barcode is not, he's not a true attorney. He's false. You can sue him for perpetrating and falsifying that he's a true attorney. If you demand that he validates his authority and show his credentials to show that he's a true attorney. He's not. He only has a bar badge. That ain't no attorney. That's a membership to an association. And if that's what you operating on, then you ain't no damn attorney. And so when you go to court and they be asking you, do you have you have to have a license in order to practice law? Okay, then you should be asking that anybody in here that's practicing so that they have the authority. Since you're asking me for mine, then have you asked everybody else for theirs? Can I see everybody else before we move forward? Before I reveal anything to you, I need to see everybody else's, and we're gonna all reveal to each other today the authority that we all have. You see what I'm saying? It only makes sense how everybody asking you to provide and nobody else is providing nothing, right? So the most important document is for you. Everybody say the birth certificate. No, the most important document to come in with is a power of attorney. What? A power of attorney. For the legal U.S. person, individual U.S. person. You can put that in there as the one granting you the authority to act. You're acting for the U.S. person, not for yourself, right? As the principal. But as the U.S. person, that's you acting in a legal capacity. So when they say, "Oh, the U.S. person acting under my legal authority as an agent acting," see, when you come into the court, it ain't about whether or not you come in saying you the representative. Have you put a power of attorney on file for the principal? The principal record that's being charged, is there an authoritative figure coming in? Now, when you got this power of attorney, now you can make proper representation into the court. As an attorney, in fact, you would do the same things that all attorneys are required to do. Now, I ain't gonna give y'all the juice. But listen, I ain't gonna give y'all the juice. I just trying to get you to see it, right? So we know what we know, y'all. Hold up, let me go back. But I don't want you to forget. Hold up, where it go? Right here. Transaction means a transaction that is conducted for the entity that is involved, that involves the power of attorney. And the reason why you gotta see it's an entity because it's a sole proprietorship, meaning you are acting as an entity and as an actual person. Both. All right? Acting as both. And your body is your administration. You are administering all of your acts and deeds through the administration of the individual, right? So when you understand that aspects of things, then it makes a lot more sense. So go read this right here. No, I ain't gonna go too deep into it, but I just want you to read this and get an understanding of what it's pertaining to. Let me see. And they basically pretty much tell you all the authority, execution. See, then you got the judicial relief, dismissal, petition, right out, see? See? You just gotta, everything is in here. So it ain't that they don't acknowledge or know it's about proper procedure. You doing things within the requirement. So they can't tell you that you can't be an attorney in fact. See what I'm saying? By way of fact, you have the rights to turn over anything that you have possession of. So if the flesh is possession, then you have the rights to direct the flesh to give you direct power over its affairs because you are the one controlling it. So at any given time, the intellect within the flesh can empower itself to act as authority over the matters of the principle. Character known as the person or what you call the human being. I don't care what you want to identify it as. Okay? We ain't playing this game with y'all no more. Y'all play too much. And playing games time is up. It's up, man. All right, y'all take this because this is what you need to be filing into the court, right? A POA. And then you need to forget all that. You need to be a lawyer. No. You don't need to, no. It said, woe to you, lawyers. The Bible say, woe to the lawyer. Because the lawyer ain't nothing but a crook. A lot of them crooks. We know it because the book speaks badly about it, right? Now, let me show you one more thing. All right, because look, if you lived in any state, you can pull up the act, the Uniform Power of Attorney Act. But we want to do what's called a dual power of attorney. And they also have a dual power of attorney act too. So you can look up the dual power of attorney act and you want to read that. And basically when you make your power of attorney, you want to make sure that it's in compliance with the state. You want to say power of attorney under Illinois' Power of Attorney Act for blah, 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 blah. And you create your power of attorney like that, utilizing the state act that supports it, right? Which gives it relevant standing in those proceedings, right? Now you can't be told that, the reason why most people don't have an attorney or are told to have an attorney because when you're representing yourself, then you must appear into the case as an attorney. And if you can't do that, then you might as well stop playing. You coming in, you can file all the paperwork you want. If you ain't got this document right here, you just playing. I'm telling you, you just playing. You just have the little play time because this is the document you want to put in the judge's hands, the prosecutor's hands, and in the clerk's hands. You want everybody to know of your authority, right? And your ability to administer and control whatever entity in which is being charged in the proceedings, right? Now let me show you this. Thing real quick. And I got y'all, any attorneys, y'all go get them attorneys and tell them, man, Brother Isaiah up here exposing. I'm exposing. Because the people need to know the truth. Because if you don't know, you don't know. They running around here perpetrating like they real attorneys and they ain't even real attorneys, man. And they got my peoples up here going through all this bull crap. Y'all up here faking stuff, man. This right here is called the courts, right? Y'all see it? Chapter 70, 705 courts, 705 Illinois, 205. It's called Attorneys Act. See that? See that Attorneys Act? Oh yeah. Y'all, brother Isaiah, I tell them I'm bad, boy. They better quit playing with me, boy, because I ain't got time. I'm gonna start really exposing y'all here, man, because it's that time, right? So this act may be cited as the Attorneys Act. No person shall be permitted to practice as an attorney, huh? Or a counselor at law within the state without having previously obtained a license for that purpose from the Supreme Court of this state. Oh, wow. Oh, no, he didn't. Oh, yes, he did. Oh, yes, he did. Did I just expose they whole little system they got going? Oh, you dirty dog. You dirty dog. You told me I had to be part of the part. Oh, they wanted to practice law. But I couldn't find out that the real license. Oh, you dirty dog. Y'all see this? Oh, dude. I can't believe it, man. Look at it, man. I want you, matter of fact, take a, man, look. I don't care what you got to do, but you need to lock this in, man. Look, do you see this? What? God, they got all kind of TV shows, bro. So y'all just let these people make fraudulent shows, just promote fraud everywhere. Everybody talking about this bar stuff. That ain't even, no, they gotta have a real license. So you can expose them prosecuting attorneys when they ain't actually licensed. You know what I'm saying? If they don't have a license from the Supreme Court, and 9 times out of 10 they don't. That's why they're in the lower courts trying to get off. It says no person shall receive any compensation directly or indirectly for any legal service other than a regulatory licensed attorney. Nor may an unlicensed person advertise or hold himself or herself out to provide legal service. That's why this goes in accordance to the Fair Debt Collection Act when it says that they can't act like they attorneys if they not attorneys. You see what I'm saying? So now you understand, like the bar is a private association of what they call attorneys, right? But they not real attorneys. So this is where you get them at, like when they send you letters in the mail saying they attorneys. Okay, this is how you can get them. All right, I'm just showing you, I'm just exposing the hand. Like, don't get mad at me. I'm just showing y'all the truth. Hey, the license as provided herein constitutes the person receiving the same, an attorney and a counselor at law, according to the law and the customs thereof, right? Or in doing his good behavior in the practice, and it authorizes him to demand and receive fees for any services which he may render as an attorney and a counselor at law in this state. No person shall be granted a license or renewal authorized by this act who is no more than 30 days delinquent in complying with the child support rule. A license or renewal may be issued, however, if a person has established a satisfactory repayment record as determined by the Department of Health and Family Services, formerly Illinois Department of Aid, for cases enforcement under. See, so it's basically saying, because you even got attorneys that's dealing with child support. That just goes to show you the diversity of law. You got attorneys that's dealing with child support. If that don't wake you up, come on now. Come on now. When we say that the creator, the divine creator, given divinity, give us divine guidance and knowledge of wisdom and understanding of things that only can come from the divine. We're not playing with y'all. Y'all better, it was predicted only 144,000 will wake up. But a lot of y'all don't believe. You think that this is not ordinary information. The things that I'm showing you is not stuff that you would find or see every day. Understand. It's not something that just comes out of the blue. Okay, this is well researched, thoroughly investigated, studied information. I'm not doing this because I'm guessing. I'm doing this because I'm qualified to do it. Each one teach one. That's what we're supposed to be doing, is helping to educate one another so that we know the truth, so that we can prevent the corruption, the things that they're doing. But in the service of serving each other, we got to show love toward one another. You got to give your brother the same thing that he gives in return. You got to show love. You got to be able to support the channels, to give out the information, share the information out to others so other people can get it. Or else you just as worse as everybody else. You're allowing the evil to continue to prosper because you won't help get the information out. You'll take it for yourself, but you won't share it for other people because you want to be the one known for it. Or you don't want it to be known that you got it from another person. Or you got other means of how you choose to use the information. So you can't just blurt out, say, man, I give this brother his credit for what he did. Let me support this channel. Hey, y'all go support this brother, his channel, what he doing, because a lot of y'all got alternative measures. Your heart ain't right. Your mind ain't right. That's why you're limited. That's why you only got so much ammunition. And you gotta wait till somebody drops something of significance for you. And this ain't, if you think that this is basic, like a lot of stuff I can't even show you. Why? Because I already know where much is given, much is expected. Why? Because a lot of you guys ain't gonna do the right thing with it. Nor will you appreciate it. Why? Because you didn't have to put no work in for it. You see what I'm saying? So that's why I ain't gonna never just give you no forms, no. Now I could be showing you a lot of stuff. Now if you part of memberships and everything, like, you might get other information that is not privileged to the public. It's certain stuff I could be showing you right now that'll blow your socks off. Well, why would I do that? For what? What have you actually contributed to the cause? Have you donated to the cause? Have you shared the video? Have you giving out likes? So that's why I'm giving this information. But it takes, it's to give it, we gotta both work equally. Once I start seeing the likes go up, shares go up, and the people really enjoying and responding. So that makes me want to give more or do more in order to entertain the people on a higher frequency. But if the frequency's still low, if people barely giving likes out, barely sharing out the information, of course, I'm vibing on what you giving me. I can only go off what I receive, right? So that's why I say you gotta give love in order to receive it. You gotta be equally exchanged, And I'm actually giving out a lot of information today, some basic information, but I've given you different things that you can go and research and study. Even though I've shown this to a lot of people, a lot of you guys still ain't. You ain't gonna get it. Still don't know what to do. Still at ground zero. Don't know which way to go. And guess what? You're too selfish to say, well, I'm gonna get in contact with this brother and get a one-on-one with him, maybe, see what other services he may provide so I can start learning from this man and maybe learning some of the things that he has, other things besides what he's just actually showing public. Because I know that he got other information that could be very vital to me, family, so forth. And it's things like that that you have to always keep in mind. Let me see. So that's the Power of Attorney Act, right? So that act, this is something that you got to use with the judge in the cases, okay? A lot of y'all just create powers of attorneys, and then they try to deny you, okay? When you make the power of attorney, you want to make it in compliance with the regulations. So whatever regulations, whatever acts the state has authorized in reference to the type of activities in which one is operating under, then that's what you support it by. Okay? You support it by these acts, these things. These things are placed into your document in order to substantiate the document's existence and rights of administration, right? So understanding your duty, your responsibility, knowing what you need to be looking for, what you need to be studying is critical. I just gave you a couple of little Jews for the day, and I got some sales going on the website. So go to buildingbetterminds.info. Go to our event page, and you'll see all our current events, all the different things that we got going on. If you want to be involved, I suggest that you always get knowledge, wisdom, and understanding in all your dealings. Hopefully this brought a little clarity to some of you guys who just seem to not understand or you know get what's going on. But get it together now. Get it together when you're dealing with uh, fiduciary relationships and things like that of that nature. Make sure you got your power of attorney in place. Because that power of attorney is going to be very, very significant uh, to your ability to do the things that you desire. All right, in reference to controlling the principle. And with that said, I leave y'all as I always do in love, truth, peace, freedom, justice, and equality for us all. You guys have a blessed, have a wonderful day. And by all means, study to show yourself approved. Because knowledge is the key to unlocking them doors, especially when it's applied properly. Peace and love, man. I'm gonna catch y'all in my next one. Bye. Let me see. Look at this chat real quick before I go. See what y'all chatting about over here. Peace to all the beloved brothers and sisters. Yeah, you got that Treasury Direct set up. yeah, yeah, I know, man. You know, a lot of people don't get it. They just don't. They don't get it, man. You know. Yeah, the EFT, real deal, Holyfield. Like, like, boy, like I said, I can show you some things now. I can show you some things. I can take you into the byways and the highways of information and show you some things. Like when I say that the highway to information is amazing, like, man, listen, I got like when you can walk into a bank and you got certain information, you can file complaints and disputes concerning certain regulations that the bank is not in compliance with. Is it changes the dynamics when you have knowledge, man. That's why the key to you being successful determined by what you know. It's about what you know. Yeah, and a lot of people don't know. Like a lot of people don't. What a lot of people don't understand is like when you get approved for a debt, approved for any kind of loan, the company is approving you for finance or to receive an advance payment, right? Which is also a collectible amount that can be that they're going to collect on, right? When the consumer is approved to receive due balances on an extension of credit, those due balances becomes performance, meaning the consumer can earn his rights to pay. To earn your right means to perform to receive payment. So the earned payment is one you perform, right? When you actually take the performance to gain that right to receive that balance by paying it directly. And when you directly pay, then that's the balance received. That's an earned payment. But a consumer also can earn that right or receive payment, right? Through collections, right? So like a 1199A form can be filled out at the inception of a contract and a disposition order issued by the consumer, directing funds to be uh, credited or directed or deposited directly into this account for processing payment. You see what I'm saying? So it's just like you have the rights to do those type of dispositions. You just have to know how to take action when the time is right. And a lot of people don't know how to take action, right? Like, see, another thing that a lot of people don't get is that, you know, there's two sides of a coin. You only operate from one side, but there's another side that's unseen. And in accounting, we have what is known as matching principles. Matching principles in accounting is where two numbers match each other equivalent, where -2 and +2 are the exact same value, and they only can be used to settle. So -2 can't be settled by a +3, a +4, a +5, a -6, a -7. No number will settle that -2 besides another two that's positively opposite of it. It has to be the exact same matching principle. See what I'm saying? And when you understand how matching principles work in an accounting system, every contract creates a double bookkeeping entry. it creates a double, what we call a matching principal, to where the principal is provided and then there's a matching value of the principal loan that the lender collects on, or that is a due balance to be paid. And when you understand that that comes with accounting, it's called matching principal. So if I have a positive $50,000 loan as principal, it will be considered as the principal would always be the tangible item itself. So when you say principal, I have a principal $50,000 loan, you're saying I'm holding a $50,000 item that's valued at that amount. What makes my lease 50,000? Because the value of the lease is 50. So just holding a $50,000 value item gives the item a value of 50,000 in your hands. And it's so crazy that we don't even see it like that because we only use the value when we have green dollars or written check. So when somebody approves you for finance or an extension of credit and you have the amount directly in your hand, you don't even know it's there. You so oblivious to the value being provided because you only looking at value as green dollars. Man, y'all better listen to what I'm trying to tell you. You better come up out of that spell that you under and realize that you need to wake the hell up and become aware, self-aware of what's going on around you at all times. Okay, you're giving away stuff, not even aware of what you're giving away because the way it's written. So, whenever you receive a principal amount, there's always a matching principal. So if you get an instrument and it's valued at 50,000 in your hand, then there's also an unpaid balance of that same amount in your possession. So that means you're not just holding a $50,000 instrument, you're also holding the matching principal of that same item at the same time. Now, usually, if the principal is above the zero, meaning that the principal balance that you hold is a positive balance, then the matching principal usually will be negative because it will be the opposite of that which is positive. Now, in your mind, you'd be like, well, how would one pay what he owes if it's a negative balance? So I had to figure that out. I had to do some research, man. I had to do some studying. Because if all the amounts that are due that you owe are negative balances to be paid, how are you paying your debts? Hold up. Let's look this up because I need to understand. I want you to explain it to me because I'm trying to get it. I'm trying to understand, right? Okay. Okay. Now, in accounting, system guy, 6 step smarter guy, but let's get down. To understand the matching principle in accounting, consider these key points. The matching principle dictates that expenses should be recorded in the same period as revenues they help generate, right? The principle ensures that financial statements accurately reflect a company's profitability. It helps in aligning the costs with the associated income, provided a clear financial picture. Right? So when you understand revenue and expenditures, right? And expenses, they have to report both what's coming in and what's going out at the same time. But the matching principle is it's called debits and credits. All right, now this is very important. Why? Because this deals with your bank account and everything. When you understand, I want to show y'all an example of what I'm talking about so you can see what it looked like, but I'm not going to do it. I'm going to give you some homework to go do it to yourself. I want you to go to like YouTube and look up, they have videos on the matching principle, concept of the matching principle in accounting, and start watching those basic fundamental videos to get an understanding of what the matching principle is and how the matching principle works in reference to a company when it comes to their books and their expenses and revenues when they're receiving property and things like that, which will help you understand the matching principle aspects of how this system actually functions, right? So, and when you're dealing with the bank, the bank operates under these same accounting principles to where whenever they receive a deposit, they have to give equal credit matching that deposit, right? As far as in accordance to accounting, right? So basically, what I'm saying is when you deposit an instrument into the bank immediately gives you credit, right? Now, let me show you something. Now, when I told you, I said that the matching principle It's always negative, right? It's a negative amount that they owe. So if you give them a lease worth 50,000 on their books, they have a negative 50,000, meaning they have a deficit of 50,000 that is due, meaning that they owe 50,000 because they received the credit of 50,000. So a matching principle of the same value has to be returned, right? So when you understand that aspect, it'll make more sense to you, right? When you go to, I'm gonna pull it up. What is it? Let me go here. You go to 31 USC 18, what's 1813 L. And when you go there, it pretty much shows you what a deposit is, right? Now check this out. Now when we go down here to deposit, and I can show you a lot of things, but deposit, all right? So the term deposit. Like, so when you go to the bank and you make a regular deposit into your checking account, right? The unpaid balance of money. Now, why would it be an unpaid balance? If I'm depositing funds into my account, why would it be considered as an unpaid balance of money? We're going to get to that later. Just keep this part in. So every time you deposit money into your account, the deposit itself is unpaid. It's an unpaid balance, meaning you're depositing something but you're not being paid for at the time you're making the deposit, right? Now check this out. I prove to you that what I'm saying is true, because the truth don't need no support. All right. The unpaid balance of money or its equivalent received. See, the bank is receiving a deposit, but the deposit itself is unpaid money that it's not been paid. It's a promise to pay, meaning the government is promising you the real money for using that. So you definitely ain't got paid for it yet. So it's an unpaid balance of money. It should make sense. Why? Because we're using what? Currency. And currency is a promissory note, right? So you're depositing an unpaid balance of money. Does it make sense? Okay. Now it makes sense, right? So, or the equivalent received or held by a bank in the use or savings association in the usual course of its business for which it has given. Usually it gives credit, right? Usually if you deposit a money order, check, CD, they usually give you credit, right? Or it's obligated to give credit. It's either going to give you credit or it's either obligated, meaning you might have made a deposit and it might have returned the check. But if you know the banking rules, then you know the bank got to give credit for all deposits, right? So you know how to enforce that, right? Either conditionally or unconditionally to a commercial check savings time drift account on which is evidenced by a certificate of deposit, drift certificate, investment certificate, or certificate of indebtedness, or other similar name or check or draft drawn against the deposit account. So what it's saying? I can't make it up, bro. Bro, I can't make it up, bro. Bro, I can't make it up. Like I didn't showed you so much fire just in this one little line. Just by me just outlining stuff for you to pay attention to it, because I know you ain't paying attention. I know you ain't. So, or check or draft drawn against the deposit account. See? It's an unpaid balance of money. So if you was to draw a check, hold up, I can't make it up, man. I ain't gonna even give you no thoughts. I'm gonna let you think for yourself, because that's what you should be able to do, is think for yourself, right? All right? I just showed you something, right? Whether you catch it or not, that's something personal. Or letter of credit or traveler's check on which the bank or savings association is primarily liable. So why is the bank liable for all these items? What? so the bank is liable for a traveler's check? Wait a minute. So the bank is liable for any item that it receives? So if I gave the bank 5 checks in the last 6 months, why? It's saying the bank is liable to me for those checks. Huh? Am I making it up? Provided that without limiting the generality of the term money or its equivalent, right? Any such account or instrument must be regarded as evidence in the receipt of the equivalent of money when credited or issued in exchange for checks or drafts, or for a promissory note upon which the person obtaining any such credit or instrument is primarily or secondarily liable, or for a charge against a deposit account, or in the settlement of check, drafts, or other instruments forwarded to such bank or savings association for collection. I mean, I shouldn't even have to spell it out for you, but I'm gonna highlight it for you. I just want you to look at that and maybe read that with a little bit of sense, okay? Just use a little bit of common sense, please, without me having to say what I think, okay? Just look at it, look at the commas. What does a comma indicate, okay? And then I want you to read it, understand what it's trying to tell you, and take it from there. Okay? All right? I'm gonna let that ruminate for a minute. Okay? So now we got all these different things. So now we understand now, right? Why the bank is primarily liable. Why is the bank liable for the checks that you deposit in your checking account? Huh? It ain't because you spent the money on the check because you never even got paid for the check. You ain't got paid. It just told you right here, a deposit is an unpaid balance of money. All right, so the check is something equivalent to money, but you haven't been paid for it yet to receive its money's worth. You deposited the check or the item, something equivalent to money, but the bank ain't paid you the money yet. The bank gave you credit, but it ain't gave you no money. Oh my goodness, man. Listen, you can thank me later, man. That's what I'm trying to tell you, man. Hey, listen, one day you're going to learn how to read like this, and it's going to be a fascinating thing so you can teach this to your children, right? So we got a deposit, which represents money or money equivalent that the bank owes for receiving the deposit of the money equivalent, meaning the bank gave us credit for the item, but it never paid us the equivalent of money for the receipt of the deposit. So now you know. Now you know. Now you know. I'm done with it, man. I'm done with it. Let me get back to where I was at, man. Because this don't make no sense. It don't make no sense, yo. Don't make no sense. So now you feel me, right? See, like when I say, hey, the information is like out of this world. Hey, listen, I can't make it up. You just gotta know who is who, man. You just gotta be aware of people that you're watching and what they providing and things like that, because some information, man, is very important for you to have. Like what I just showed you, it's very important for you to understand, like when I say the matching principle, the double bookkeeping entry, meaning you're dealing with fiat paper, you're dealing with paper that promises or carries the appearance of a monetary value of money, but it's the appearance, but it's not the actual form of money. It's not the actual money itself. See what I'm saying? So all they've done is found a way to represent value without actually providing value itself. And they operate off the promise of the representation of promise to move value from one place to another, you know? So, man, like understanding the banking system, man, is one of the most delicate, most important aspects of everything that's going on, because pretty much everything you do, you're going through the financial system in order to do things. Your banking relationship, your relationship with the bank is one of the most important relationships that you have, because it could either be to your benefit or it can be to your detriment. I mean, it could be good or bad depending on your comprehension and your level of understanding of what it is and what you have, and your ability to manage your own affairs and things like that. Even with a trust account, if you don't know what you're doing, it really don't even matter if you don't really comprehend, how to manage the property, how to make the payments, or how to pay out to the beneficiaries. If you just drawing up documents and then recording stuff, using documents, don't really understand your position or how to operate it, well, what good use is it? If you haven't even read the right information that pertains to the type of activities that you're involving yourself in, you don't even know none of the codes, the statutes, you don't know none of the constitutional provisions. Matter of fact, you don't even know no other information that breaks down how trusts work, or where to find any information on Trust Act. You just going off a couple of videos or something you seen on a live or a class you took, and a trust document that was handed out to you. But other than that, you don't really know too much about trust itself. You don't know what acts to read that break down trust, or where you can find it at in the state, or anything. So when you operate from a standpoint like that, then of course you're gonna have a lot of shortcomings. You're gonna have a lot of bump ins, because you're not taking the responsibility yourself to be responsible for the things that you desire. Whatever you desire, you seek it out. And when you seek it out, then you act on what it is that you found, right? But if you don't, you gotta educate yourself in order to have knowledge. You don't get knowledge without education. Education is the key to giving you knowledge. A lot of y'all want to be free, but you're not mentally free. You're not spiritually free. You still running around acting like a slave. You still running around subservient to your flesh. You still running around identifying by the flesh as the sole identity of who you are. You don't even know how to even control your own property, or reap benefits from the usage of property. Matter of fact, a lot of y'all don't even see this thing right here as property. You become so conducive to it, to the point to where, like, you so wrapped up in your flesh that you don't even realize that the flesh is just a vessel. And it's more to it than just than what meets the eye. It's a whole lot that goes along with this, man. It's a whole lot of responsibility involved in this. Like, look, I'm gonna show you how real it is. I'm gonna read something for you. Like, when I say I got stuff for you, I just can't put it out there for you, because it ain't. A lot of people are just, you gotta do your own research. You gotta figure things out for yourself. I can only advise you to study to show yourself approved, and what I give is out the kindness of my heart to try to help other people. But at the same time, each and every man got to do for himself. You got to figure this out, and every man and every woman is worthy of their height. Yeah, I can show you some things. It ain't just me talking. I can actually show you some things. I'm gonna read something to you. All right, it's called claim right. Listen to this. Claim of right is an 18th century term and a concept whereby certain inherited property rights normally endowed or entrusted to an estate, but otherwise claimed and registered by another estate, may be reclaimed. Okay? So it's talking about property endowed or bestowed upon a person that may be registered through a higher estate, but may be reclaimed as property of another person, right? A claim of right presumes the existence of three fundamental elements, being enclosed right, a valid title, and a valid claim. An enclosed right is a right of use, form, or property to which an estate would otherwise naturally or would otherwise be naturally entitled, right? So it's basically saying that the enclosed right is the right of the estate to use the property. A valid title reflecting the other estate has formalized its claim, and a valid claim reflecting both custom and argument of the estate as well as the competence to claim the right. A claim of right, by definition, is specifically associated with one enclosed right, one valid title, and one valid claim. A claim of right is automatically invalid if it does not contain one or more of the fundamental elements, or if it seeks to address more than one title or claim in the same instrument. A claim or right must be proclaimed, witnessed, and sealed before a court of public record of the estate making the claim of right to be valid. The registering of an original claim of right into the other estates or higher estate has the effect of validating the other estate's original claim. Once a valid claim of right has been duly registered in the public record in a manner of an estate, the notice of claim of right may be prepared as a valid notice, including the extraction of a claim of right in the body of the notice. A higher estate, which is holding the property of a lesser estate, obtaining legitimately and without fraud, has the right to demand fealty as condition of acknowledging a valid notice of claim of right. Right? So this basically is basically letting you know that what a valid claim of right is, and understanding when you have to go through a higher estate in order to make certain types of claims. Like, I didn't even know what a higher estate was until I really started, like getting into this stuff, right? All right, give me a second. I gotta go into the trenches real quick so I can find what I was looking for so I can read it to you real quick. Because I read some like these, it's got a lot of sacred texts in it, right? So I went in here and I was like, sacred text. So I wanted to see, because I found some stuff on Africa that kind of, like threw me for a loop. Like, I never knew certain stuff until I found certain books. All right, so I got this book. It's called the Book of Adam. I want to read some of this book to you. All right, check this out. All right, so I got the book of Genesis, the book of Exodus, the book of Elohim, the ages of kings, the apocalypse, and the awakening. Right? Now check this out. The age of man, the golden age, the age of secrets, the age of wise ignorance, and the age of divine redemption. These are all books, okay? Now check this out. Now, I want to go to this book of Adam. Check this out. Let me read this. Now, the book of Adam, let me show you how many chapters it has. It has 12 chapters. All right, I'm going to chapter 1. Now, listen to this read. When I read this, I was like, man, what the hell is this? I never even knew that there was but it's some other books and stuff that's in here that I've been reading too, right? Now check this out. This blew my mind because this helped you. This right here. Oh man, I can't. Hey, listen, I'm just gonna have to read it for you. This right here is crazy. Hey, check this out. It says 190. This chapter 1. 190,000 years ago, the great overlords became agitated. The gray, Grey, the gray, like some gray overlords, right? It says the great swimming, the great swarming was coming on account of the cycle. The earth would be plunged into winter for thousands of years. Fearing death above all things, the Greys counseled all of the gods. But for our kind, having no time until now for freedom, never tasting the sweet delights of divinity, until earth. Now the joy of being gods over lesser beasts. This had become our home. This had become our world. The Anunnaki, troubled at our reluctance to space the coming comity, appealed the wisest of our kind. All but a few stood firm. For some did relish the days of blood as themselves as the most feared warriors in the sectors of the galaxy, to return to what reason they were first formed. But for the reminder come death, come destruction, would stand firm. The Greys saw our commitment to stay, to hold what we had given, and were impressed. Then an extraordinary thing happened. Upon our choice to stay and face oblivious, what is it? Oblivion, whatever, I'm about to look that word up, oblivion. So this is basically Adam telling the story of their creation, right? And it's talking about the Greys, right? Whoever the Greys are. And it says, the Greys bestowed upon us access and knowledge to their technology. So jealousy guarded. So it's saying that they didn't have no knowledge, they didn't have nothing. And then these Greys, whatever these things were, they were supposed to be some kind of rulers. Gave them knowledge, gave them technology, gave them information, right? It says the secret of their genetic wisdom, the secret to their machines, the secrets to their science. To our wisest, such revelations were themselves a great blessing. For in our hands, in our minds, for the first time, we had the keys to our salvation, our future. We could architect ourselves into what we choose to be. An antidote to our thousands of years of pain. Okay, now that's chapter 1. So I'm reading this and I'm like, man, what the hell is this? I ain't never read nothing, so I'm steady reading it, right? Listen to this. It says, you cut our arms and feel pain. You burn or chill, and the agony spurs you on to wish for a quicker death. Imagine then 10,000, 20,000, and more years of pain unyielding, to curse an immortal God with the ever-changing deformities of virus attacks. Now, as we stood with the cure to our damnation on the eve of destruction across much of the blue planet, we were a new race, not IGI, but Elohim, a demon, an angel. Man, hold on. Let me read. Wait a minute. Let me read this again. Whoa. Listen. It says, now we stood with a cure to our damnation on the eve of destruction across much of the blue planet. We were a new race. Not IG, not IGI, but Elohim and demon and angel in all manners and breed of gods. For better or worse, we reassign our fate to the same earth beneath your feet. The asteroids hit from the north across the land you call Greenland, Canada, and the Arctic. So many such seeds that shook the earth, sending great volumes of dust and debris into the atmosphere. The fires from the impact choking the rest of the earth. Then came the cloud. So much snow and winter storms covered the land. Our home land within the ATL mountains was covered by thick snow. So it said their homeland was within the ATL mountains. And it was covered by thick snow. We abandoned these places as snow turned into ice. Our fields and our cities covered in ice for many and 10,000s of years to come. We sought refuge with our brothers in Africa, in Asia. Now, I never read nothing like this in my life. I was like, what the hell is this? Now listen to this. Man, this right here is something, you have to read this, but this is basically it's talking about Adam in the creation of Adam. And it talked about all his suffering and what he had to go through and everything, right? Listen to this. It says, a secret you dare not face. Yet you see through your life, knowing, feeling, sensing the truth of it. Yet denying its possibility. With all of your ignorance refusal. You were created by us. You did not evolve of your closest kin from which you cloned your essence. It was the singing giant you hated the most. You are our creation. It says, we are your God, no other. And for a time, you did honor the truth and worship us as so. Now, consigned to ignorance and the petty secrets of old men with too much power. The story once sung by your ancestors to be sung at their true pitch. So it's talking about how Adam was made by these gods, and they get to going in deeper and deeper and deeper into it, right? But I'm still studying it for myself. You know what I'm saying? Like, this is new information that I came across. And a lot of these books, that's the book of Adam, but then you got the book of Elohim, where it talks about, and I think the book of Elohim got 10 chapters. And the book of Elohim is and this is it's crazy because it's talking about the graves a lot. is talking about the Anunnaki, and it's talking about Elohim was a mighty warrior, and he was the first to gain confidence and set about the bloody frenzy. They battled themselves night and day in blood of all manner of the animals they found. They killed many of the livestock and set out east over the mountains range to a lower valleys. Others, under the leadership of Yod Elohim, took it upon themselves to start to wreck the cities and buildings of the graves. Others, under the leadership of Damien, still sought to escape this prison valley in the sky and find their own place. For as long as we had been immortals, we had been mere slaves. As far as we had traveled in as many worlds as we have seen, our lords order us into war without rest. Now, for the first time in our existence, however brief, a planet was ours. Those that had become widest of our kind to the science and the knowledge of the graves spoke for wisdom. There are, it says, three of the wisest, M-A-M-A and K-I-N-G-U, and the others, one sought the audience with the others. They appealed with the leaders of the groups to refrain from such destruction and madness, to learn from the technology of the gods, and find a means by which they might cure, that we might cure ourselves of the cursed diseases. But many of our kind had tasted the fruit of freedom, the power of anarchy, and refused to yield. Instead, those who had learned much of the technology of our creators were exiled. Our own kind took me, took Mama, took Kingju, and the wildest of the wisest into exile. Using the signal craft that was captured, they transported us to the foothill of the great mountain you call, I don't know how to pronounce that word, 192, but this, man, this stuff right here is like, this stuff right here is deep, man. Like, I'm trying to figure out, because in many instances, it seemed like you had a people that was basically being treated like savages or whatever, and they wanted to be free. And they envied everybody that put them in that position. So they did things and they learned knowledge in order to free themselves and took over everything. Like, and I'm looking at it like, this can't be what I'm reading, but in so many words, it's like, and then it's saying that they got knowledge from these gods called the Greys that gave them certain knowledge and technology to do certain things, to do trickery, witchcraft, and all this other stuff that they able to do. All right. Give me a second. I'm trying to find something that I want to read real quick. Yeah, I've been reading out this I mean, I guess it's a website out there. And it got a lot of great information in it. But I haven't really had a chance to really look over all the aspects of what it is yet. I'm still trying to learn how to navigate the website because it's pretty complex website, but it has tons of information. And I'm gonna read something to you because that's all I can do right now. Okay, that's all I can do right now. All right, so I'm reading from the Civil Code, the American Civil Code. This is Article 12, Living Rights. Every man and woman is entitled to certain rights and freedoms without distinction of any kind, such as race, color, sex, language, age, religion, political, or other optional national or social origin, property, birth, or other status. It is an absolute right of all living men and women to be alive. The question to birth is separate to the right to live, right? No man or woman should be allowed to take the life of another human without their free will permission, no matter what the cause, no matter what the cost. The right to die must be rested wholly upon the desire of the individual and the will of the individual. Every man, woman, and child should have access to adequate food, clean water, clothing for survival, whether by freedom of choice afforded by a well structured society or by the provisions of adequate food and clothing for those unable to gain access to their own means. An enlightened society upon one that provides its members choice from the wide range of sources, the food and clothing, right? So all of this deals with it talk about equity before law. Men and women should be regarded as equal before the law and be entitled to, without discrimination, to equal protections of the law. Okay, and this right here is just like I said, I'm coming from Hold up, I'm find something else in here real quick for you to read. All right. These are the standard rights of men and women, y'all. Standard rights. I'm going to read some stuff for you today. Y'all bear with me. The standard rights of men and women are those standards by which an enlightening, just, and moderate society set rules for the conduct, rights, and support of all men and women. Hold up. Now let me go to another section. Civil rights privileges. All right. Standards of the human child. Standards of the human. All right. I think I'm gonna have to go to another set. I'm trying to see which section it was that I was looking at. Let me see. Mm. I gotta bear with me because, like I said, this is some new information, and I'm trying to make sure I find the right stuff. That ain't it. Yeah, I don't know where I put this information at, but I had some information that I wanted to share, and I can't seem to find it. Let me see. Oh, here it is. I found it. It took me a little time. All right, so these is like almost like human right, pretty much. I thought I had it. Nah, this ain't the right one. It's another one in here I found, man. I just can't find it right now. I was trying to see if I could find it, but it talks about the one that I'm talking about. It talks about yeah, it talks about ownership of your name, your property, everything. It breaks it all the way down. Yeah. Now, I'm gonna have to just come back, man. Maybe have to find it. Yeah, but wait a minute. I think I'm in the wrong place anyway. Oh yeah, I'm in the wrong place. Let me see if I can find this real quick. The last time I went here, I don't think it worked for me. So y'all bear with me and see if it's gonna work this time. Because they got all these different, like, they got different unions. Like, what I've learned is that they got covenants worldwide, like different countries. Man, they got covenants and stuff we don't even know nothing about. So I've been able to find some stuff. So I just want to share some of the stuff I found. All right, so this one right here deals with, let me find it. Is this the same? No. Oh, yeah. Yeah, I'm in the right place. But they blocking a lot of these, so a lot of these I'm trying to tap into, they're not allowing me to tap into them. So they don't want y'all to have that information. So I just wanted to let you know that you got to seek out information in order to find what you're looking for. And the more you study, the more you educate yourself, the more you'll be able to research. Uh, the more knowledge you have, uh, it changes your ability to seek out certain information. Like when I first started, I didn't have an idea of what to look for, what I should be reading, even where to start. It's like not even having a starting point. So once you start, you just gotta find anywhere and start. Even if you start just by you reading the Uniform Commercial Codes, if that's where you start. If you start by reading your Constitution, if child support case, court case kicks in and you start learning the court procedures and that initiate, or whether you start trying to fight, clean up your credit report, and that initiates this whole process of learning and growing into this state of information. No matter how you come into the body of information, the thing is to get yourself involved and start learning as much as you possibly can and start acting on some of the information while you're still alive, while you still have the opportunity uh, to set things up for you and the beneficiaries while you're still here. Learning about the estate, learning about property, the trust, learning how to manage your affairs, learning that what our government really is and the covenant that we have with the government, because we're under covenant with them. Uh, they've already agreed to do certain things, and certain things are already locked in stone, and the system is designed to function a certain way. It's your non-acceptance of performance or your unawareness to how things function that causes you to incur a charge or fee in the process of administration of accounts or things like that. So learning, growing, and gaining the right information is one of the best ways to prevent yourself from being surety, to being debtor in an obligation, learning how to, uh, stand with capacity, because a lot of people say status, but status correction is correcting your legal status. That's status correction, correcting your legal status, because legally you do hold a legal status, and either you are a taxpayer or you are agent or an officer of an agency. It's one or the other. So, you got to figure out how you're administrating your affairs. And when you start to determine the way that you would like to do administration, it'll change the way you operate. You know what I'm saying? Because um, nobody's going to tell you how to do what's best for you. We all have the same rights and the same privileges, and either you're going to adhere to them or you're not. And some of you guys is trapped in what we call the rat race. You're too busy chasing the dollar bill, working for fiat currency, a promise to pay, not understanding the insurance or the bankruptcy, understanding the depository insurance. Like, I suggest that you go read the depository insurance. You need to read that. Do you know that depository insurance doesn't just apply to banks? You didn't know that? It doesn't. You know depository insurance applies to all deposit taking activities? If you really understand depository insurance, right? So, but the only way you can understand truly what a deposit insurance is and how deposit insurance works is to go directly to the source, to the depository insurance company, and then go directly to their act, read their terms, read their definitions, and get an understanding of what they do and what they are. And then that's how you come to a realization. You can't go to a bank and think you're gonna know. You go in there and you ask the average banker about depository insurance. The first thing they're gonna tell you is oh yeah, that's only for like when your checking account closed. Like when your checking account closed or something, or if the bank closed down, then your funds won't be lost. But you gotta realize you're talking to incompetent people. Don't you know that the average banker that works in the bank is incompetent? Even you got attorneys that are incompetent. I know it sounds crazy. You be like, how could an attorney be incompetent? You got judges that are incompetent. Do you understand that? You don't understand what competence is. It has nothing to do with you being able to do your legal procedures. It has nothing to do with you being able to fulfill the roles of your office. Competency is something totally different. You got a lot of people that hold positions that are incompetent of a lot of facts pertaining to their positions and the transactions in which they involve themselves in every day. The average banker don't know nothing about depository insurance. He just think that that the depository insurance is, the bank gonna pay you after. Man, look, it's crazy because they say that the bank gonna pay you after if something was to happen. So basically, depository insurance is just some insurance coverage. So basically, you don't really need it unless you don't get paid. So the average person go into a bank, deposit a check, $50, get a $50 credit, use the $50 credit, and feel that they funds is covered by depository insurance. So in your mind, you've already lied to yourself and made yourself believe something that's not true. First of all, the first untrue fact is that, first of all, the bank ain't paid you nothing. You never got paid for the item. You deposited the item and got the equivalent of that item as a credit. You never got paid anything. Without the item, you wouldn't have a credit. So the credit in the item is the exact same reflection. Okay? Don't get twisted and think that's because you put in a check and the bank gave you $50 credit that the bank paid you for the check. No, the bank is making the check available to you as a credit. So it ain't paid you nothing. How did you get paid? Can you truly explain it to me? Okay, how did you get paid? Matter of fact, I'm gonna show you something for all the people that think they smart. that really need to go back to school, here's this one for you. As far as you smart ones who think they know everything, but don't know nothing. Check it out. I got something. Watch this. Matter of fact, yeah, I'm gonna keep it right here. Hold up. Legal definition of general deposit. Because generally, we make deposits, right? Nobody really makes special deposits that I know of. How about you? Okay, so you really got to start really understanding, like, you've been making deposits for a long time. You really should start studying the activities surrounding deposits so you can understand, right? Look, I'm gonna show you something. To understand the legal definition of general deposit, consider the following. A general deposit involves the transfer of possession of property to another party. So when you make a deposit, you're transferring money equivalent, something equivalent to money, all right? Or something that has a value of money, all right? So what you got to realize is when you make a deposit of a check or a money order, that's considered as equivalent to money, meaning the bank is supposed to pay you for that. It's supposed to give you the equal value of that item, right? The credit that you get is a requirement by the bank's procedural law in order to give credit for all items received. So when a bank receives an item by law, it automatically has to give a credit to reflect that that item is being held by the bank. Without the reflection of the credit, the bank is not evidencing that the item is on file. So the credit and the item reflect each other. But the item itself, right, is considered as equivalent to money. So you're giving the bank money when you give them an item. Okay? So you got to remember, you just giving people money for free. Because he gave you the matching credit of that, you thinking that that's good enough? So for you to make sure that my money is available as an available credit, or you making sure my item is an available credit available to be used? So it's like putting money in the bank in order for it to be used in a different way. But you think just because the bank made the check available in another way for you to use it, that it paid you something. It ain't paid you nothing. Do you understand that they have not paid you? They only took an item and converted it into another form of payment for you to use it. So they turned it into an available credit to show that you have available item on file, which gives you a credit of that amount to use, right? But you're transferring money to the bank, right? Or money equivalent. And typically refers to funds placed into a bank account or with a financial institution. So a money order is you're putting money into the account. So the money is not the amounts that you spend in every day out of your available balance. The money is what you place into the account. The check, the EFT, the money order, the promissory note, the item that goes into the account that gives you funds to use, right, is what the bank is receiving, money. So the item is the money that the bank receives. Or with the financial institution, the depositor retains ownership of the funds while the institution holds them. So if you spent the available credit, it can't be talking about the available credit, because that don't even logically make sense. Look at what this is saying and think about the deposit in general. And then think about the available credits that you use when you put a deposit into your, it can't be talking about that. That literally doesn't even add up, right? Look at what it's saying, a depositor retains. So if you're retaining ownership over the funds and you just spent the funds by paying your bill, then how you still retain ownership if you just spent it? So it can't be talking about the available balance that you're using. It's talking about the item you put in. You hold ownership over that item, even though the bank is holding it on deposit, right? The institution is obligated to return the funds upon demand, right? Or at a specified time. See? Right? They differ from special deposits where the item or the conditions are involved, right? Now look. I can't make it up. I promise you I can't. So a deposit is an unpaid balance of money, right? Money received or held by a depository institution, or credit given for money or its equivalent. See what I told you? They give credit what? For money or its equivalent. So whenever the bank receives something equivalent to money, it always gives credit, but it still is unpaid, meaning that the deposit itself is unpaid balance of money. Meaning the bank is receiving money, but it's not paying for the money, it's only giving credit for the money. Okay? I mean, come on now, you're gonna be able to read one day. You're gonna have to learn how to read one day, all right? Because if you don't, you're gonna be giving away a lot of money. Okay? An outstanding teller's check. Why is it outstanding? Because it's money and the bank ain't paid you for it. It gave you credit for it, but it ain't paid you for the item, right? Oh no, I ain't paying any due bill, right? Or other liability, an undertaking on the, so it's telling you, you're supposed to be sending the bill to the bank. Shall sell or deliver the securities, right? Or purchase the securities for the account of any customer. I can't make it up, man. Dude, I can't make it up. I can't make it up, yo. Like I said, your problem is you don't like to read. All right? Check it out. Or a debit to an account of a customer before the securities are delivered. See? So what you telling me, I can do a debit to my account before I even deliver the security that backs up that debit? Oh no, don't give them game like that, brother Isaiah. You're giving out too much. You're giving out too much. Hey, it says a deposit arises thereafter if 3 business days from the date of insurance of the obligation, the depository institution does not deliver the security purchase or does not fully collateralize its obligation with securities similar to the securities purchase. See? A security similar of the same type and of a comparable maturity to the purchase by the customer. Right? Man, I can't make it up, man. I'm gonna stop. I gave you enough. Like I said, I gave you enough for you to understand. What you need to understand. All right. So, yeah, but I can't make it up though. I can't make it up. Like being poor is a choice. If you choose to be poor, you're poor-minded. Meaning you won't do it. You want to do what needs to be done to get what done needs to be done. Okay? A lot of people talk that talk. Can you show me the facts? Like, I see a lot of people talking, oh, you can do this, and the government said, and all you got to do is do this and do the 10 nights. Show me that in writing. Show me word for word. I want to read it for myself where it tells me I get to use the consumer must use a 1099A. Because if people are telling you to use certain processes, then that means you've read it somewhere, you got some clarification from somewhere that backs up. And now if you're reading from somebody else's standpoint, where somebody else came up with this theory and they created a pamphlet or a book or something like that, and you're going by that particularly, based off that, rather than actual code statutes or something that's saying it specifically that this is what the consumer must do, then that let me know right then and there that you're not reading from the right source. Right? Now look, because if I tell you, if I say, hey, look, if they send you a bill, that's deception. They trying to treat you as if they're doing business with you, and they're not doing business with you. They're doing business on account of your account, right? And if they treat a consumer purchase as a resale, then that's deception, and I can prove it to you. And it's in every state got an act that deal with that tell you that they're not supposed to be sending you bills. You know what I'm saying? Let's see. You know, I'm a true believer. I'm a true believer. Let me pull it up first. I'm gonna show it to you. Because a lot of y'all ain't gonna believe me unless I show it to you anyway. Yeah, they got it in. All right. All right, so like I said, when you following somebody, man, make sure that they're able to show you the truth. Don't just listen to somebody that just be telling you stuff. 'Cause a lot of people just be saying stuff and make it sound good and then say, tap the link, and sign up for the class tonight, and then you get in there and you get a bunch of information. You could I could have learned this online. You know what I'm saying? But if they can't, if somebody telling you something, you want them to prove it. You know what I'm saying? Don't sit there and tell me I can pay a bill and don't prove it to me. Don't sit there and tell me that they're not supposed to be billing me, but you can't prove it to me where that's at. You just telling me, oh, they commit fraud. They doing this. Don't pay your bill. Don't you supposed to do this and do that, but they can't never show you. You know what I'm saying? Show and prove. I live in the show me state. You gotta show me. You can't just tell me nothing like that. I don't know about y'all, but nobody can't just tell me anything. Right? Now, this is dealing with business practice, business transactions, consumer fraud and deceptive business practice. It's a consumer fraud and a deceptive practice of to practice business against a consumer. Okay, it's deception. All right, the term advertisement includes an attempt by publication, dissemination, and solicitation or circulation to induce directly or indirectly any person to enter into an obligation or acquire any title or interest in the merchandise, and includes every work, device to disguise any form of business solicitation by using terms such as renewal, invoice, bill, statement, or reminder, right? Ain't that what they use, y'all? To create an impression of an existing obligation. There it is right there. Now, I'm gonna let you see that for yourself. Why they send you bills? Can you explain to me why they sending you bills and stuff? Because they want you to believe that you owe an existing obligation when you are approved for credit. Credit is the right to reduce the amount of principal reflecting on the positive side of the zero. So if you got approved for an installment contract above the zero, then that means that you have a right to receive the due balances below the zero to dissolve that positive balance. So if anybody's charging you a positive balance toward the positive balance of your loan, then they committing deception. Why? Because they're treating you as if you owe principal toward the loan, when really in actuality the principal you owe is the matching principal of the unpaid balance of the opposite side of the zero. So that means that what you owe should reduce your loan, right? And if anybody's not reducing your loan, then that means that they're committing deception. Why? They're trying to treat you as if you owe an obligation outside of the obligation you already provided. And you should be demanding that the unpaid balance of that extension of credit be applied, because you have a right to have all balances applied toward the transaction. See what I'm saying? And that's the thing that they get away with. They never apply the total value. They only credit the item and then come to you for collection of its amounts. When actually, in actuality, you know, you're not supposed to be collecting. They're not supposed to be collecting from you. They're supposed to be reducing the obligation. And you're supposed to remind them that this is a credit agreement and that the amount should reflect the credit that reduces the obligation monthly. Every month you should receive a credit, a payment, a credit reflected on your account as an amount you agree to pay, or that you approve for the lender to credit toward the account. So if you get your statement and it's showing that a credit is being applied, of course you're going to approve because it's an approved credit. But if they're sending a request for payment demanding that the credit be paid by you directly, then that's an adverse action. Why? Because you have a right to make sure that since they're in possession, that they just apply those credits rather than demand payment of those credits. Just by you identifying ownership over the account and claiming your rights to have those credits properly applied, because they've already been purchased by you as applicable balance toward the agreement that you have the rights to apply, right? So making sure that the agreement reflects what it's supposed to reflect is very, very, very critical in being able to handle your affairs, man. I'm getting up out of here. I've been on here long enough, sharing enough information with you guys, man. Hopefully y'all really enjoyed the live. You really liked the live. Like I said, you want to learn more, you want to get more involved on a lot of other information, different forms, documents that you may not be privileged to on these lives, that you may not never see on any of these type of platforms. If you want to learn more about other things that we provide, other information that we have, then make sure you tap in. This right here is just to get your juices going, just to show you that, hey, look, hey, we ain't playing over here. We got that information over here. And we ain't afraid to share it with you to let you know that, you know, this information is public and you do have a right to access this information. Now, if you need more involvement, you need more application as to how to apply, use, or enforce, then that's where you can reach out to your brother. Since I'm the one providing this information to you, then it would not be unlikely for you to reach out to me and get in contact with me if you have any more concerns about how this information should be used correctly. With that said, I'm going to leave you as I always do in love, truth, peace, freedom, justice, and equality for us all. Like I said, thank you guys again for tuning in, for your time. And I will be returning at a later date with more information. Check us out, buildingbetterminds.info. Go to our event page and look up and stay current with our current events and different things that we have going on so you never miss any of our events. Peace and love, y'all.